Hello everyone and welcome back. In this video, I'm going to talk to you about the Marchman Act and specifically why it's so important to understand in which county you're actually filing the case in. So in law school, one of the things they teach us as law students is how important it is to know your judge. And what they mean by that is when you go in front of a specific judge, to understand how that judge rules or views a specific issue, because obviously different judges are going to view perhaps the same issue very differently, depending on their background, their training, their experience, all of that stuff. One of the other things that's really important, which they actually don't teach us in law school, is to understand which county that you're in. And that is really critically important when it comes to filing the Marchman Act. And the reason for that is that the county in which we're going to file the case is determined by where the respondent, potentially your loved one, is actually located. It has nothing to do with their residence or where they live or whatever, or any of that. If they are physically in Palm Beach County, we file in Palm Beach County. If they're in Broward, we file there. If they're in one of the other counties in Florida, well, then we're going to file in that county. Now, every county that we've experienced, and we've handled these cases all over the state, seems to do things a little bit differently. And there are just some counties that frankly are just a bit more switched on with the Marchman Act and getting the assessments done and getting the assessments filed and having the qualified professional show up for court. They're just more switched on than others. Now, last year, there was a bunch of changes made to the Marchman Act, but the biggie, the one that really we had to pay the most attention to, was the fact that instead of two separate filings, meaning a petition for assessment followed by a petition for treatment services, now it was one filing. And that meant that I had to sit down. It was my responsibility to sit down and basically rewrite our Marchman Act pleadings. And so we've gone from two pleadings, two petitions, to one. And the idea is you plead everything. In other words, you tell the court all the relief that you want. We want an assessment order. We want the cops to pick them up. We want a hearing on the treatment, on the issue of treatment services. Because if you don't put it in, guess what? It's waived. Goodbye. You don't get to have it. Now, there are some counties that appear to be still operating under the old statute. In other words, they're waiting for two filings. And we had a case that came in where somebody decided not to use a lawyer and they filed it in one of these smaller counties. They actually went and filed a petition for assessment. The court granted it. The person was taken for an assessment. And guess what? There's no hearing set. Nothing, the case is basically stalled. It's dead in the water. And why is that? Well, first of all, the particular county is operating under the old statute, which is no longer the law here in the state of Florida. It appears they're waiting for the petitioner to file the second petition, and that would trigger the court setting a hearing. But they're not a lawyer, so they don't know that. And this particular county is operating under the old statute. And so I suspect this case, even if this person needs to go to treatment, even if they meet Marchman Act criteria, I suspect this case is probably going to be dead in the water. And so, look, as I tell people, I think it's very difficult for somebody to file a Marchman Act case on their own, even if they do it right. Because ultimately, once you get to a treatment services hearing, your loved one's going to get a lawyer that's appointed to represent them, that's extremely skilled with the Marchman Act, right? That knows the rules of evidence, the rules of procedure, substantive law. I think it's an uphill battle for you to do this on your own, even if you can get into court. I'm not saying it's impossible. I'm saying it's difficult. And there's nothing worse than getting into court if you get there and then losing, because now you feel completely demoralized that the system's against you and you'll never get your loved one into treatment. And that's simply not true. I mean, we have tremendous success with the Marchman Act, but you got to know how to do this thing. You got to know how to do it right. And you got to know what petitions to file and what to put in there and what relief to ask for. And so, I point this out because I feel bad for the family because they're wondering why there's no hearing set. Well, because you didn't file the second petition. So this is what happens. And I wanted to share that with you, but know your judge, know your county, and more than anything else, know the law, because sometimes you have to educate the court and the clerk of the court and say, hey, hold on a second. There was this change to the law last year. We only need to file this one pleading, but they didn't know that. The petitioner didn't know that, and it appears the clerk didn't know that. And these things happen, right? This is why they call it the practice of law, because hopefully over time you get better at it. So I wanted to share that with you. I appreciate you tuning in, And listen, we love the Marchman Act, but we also love guardianship too. And if you call us, we'll talk to you more about how we can maybe do a bit of both for you. Anyway, thanks for tuning in. I'd love a thumbs up. Please subscribe to our channel. It really helps. And if you have comments or questions, post them. I read all of them. And I try to respond really, really quickly. So with that said, see you in the next video. Bye-bye.